number 10, the people of the state of New York versus Drury, Duval. Good afternoon, council. This is appeal number 10, the people of the state of New York versus Drury, Duval. Council?
Good afternoon, your honors, and may it please the court. Hunter Heaney for appellant Drury Duval. May I reserve 2 minutes for rebuttal?
Yes, of course, sir.
Thank you. In the often dangerous exercise of executing no-knock search, Fourth Amendment's particularity requirement plays a critical role in ensuring the safety of both law enforcement and the citizen by providing notice of the searcher's authority and limiting their discretion.
Counsel,
In this appeal,
may I ask a question, Chief?
Judge Garcia?
So I'm having a little bit of difficulty understanding what the challenge is here. So let's just, and I know some of this is sealed, but let's speak hypothetically. If you have a search warrant signed by a judge, probable cause to search a home, and in that home, a multi-generational family is living. So there may be a bedroom someplace, there may be, the target of the investigation's bedroom on another floor. You have a warrant to search the house. Would you say that warrant is invalid?
What is the text of that warrant, your honor?
Yeah, there's gun dealing going on. There was a buy made. Somebody went in the house. They waited in the living room. They went upstairs. They bought a gun. They come out, presented to the judge. I went into this home. Somebody met me. They brought me upstairs. I bought a gun.
Well, the question in this—
There's gun dealing going on here. I get a search warrant for the home.
Sure, your honor. So the question in this case is whether the no-knock warrant to search Mr. Duval's apartment building failed to particularize the unit.
But you're claiming it's a building, an apartment building, but let's say that's my warrant. It's a home, it's a house, maybe looks like a brownstone from the outside, but I go in, maybe it's a multi-family house, so multi-generational family, there are different family members living in different places, but why would that warrant in my case be invalid?
Well, to the extent that the warrant only describes a bare address with the phrase, for example, a private residence, that's defective because it's vague and it fails to specify the police were
So
actually
in getting the warrant, you have to establish, if I get a warrant for 25, Maple Street, I have to establish that 25 Maple Street is a single family home when I get the warrant.
It has to be specified on the face of the warrant whether or not the dwelling is multi or single family or something more than the bare description of private residence, which really only describes non-commercial.
So what is the Chief, if I may, what is your basis, like either in statute or case law, for saying that it actually has to say a private residence or a single family home, or some other descriptor?
I think it comes from a variety of sources, predominantly dating back to this court's decision in Rainey, which indicated that the designation building is something of really acute state interest in the state, especially in light of the multitude of multi-unit dwellings in the state.
Judge, can I ask a question on that point on Rainey? And then I'll back off. As I understood Rainey was at 529 Monroe Street. I know the area roughly. It's in the city of Buffalo. It's common in Buffalo for there to be two family houses. In the city itself, quite often you have three family houses or three apartment houses. But the way I understood Rainey was the comparison was drawn between Rainey, which is a central Buffalo double house, the comparison was drawn with an apartment building in the analysis that was given there. I didn't think that issue though was preserved in Rainey. Here, I didn't think the multiple dwelling unit issue was actually preserved. Was it preserved?
It was absolutely preserved by the motion to controvert, which specifically alleged the lack of particularity of the warrant because the warrant described the premises only as a private residence, arguing that that was vague. And then on top of that,
Well,
that the
okay,
warrant
I
failed.
understand the particularity argument, but to say particularity isn't the same as saying this is a multiple dwelling unit. There's more than one unit here. Did they say that?
I
wasn't
motion to
sure. That's why I'm
controvert-
asking you. I'm
Yes,
sorry. Go ahead.
it was clearly alleged in the motion papers in both the affirmation and
Okay.
the memorandum of law.
So you're saying that the information in those documents are sufficient to controvert the. Is that what you're suggesting?
At the very least, yes, Your Honor, at the very least, it should have warranted a hearing. That's consistent with the broad variety of precedent, as well as the appellate divisions that have held hearings on actually much more scant allegations.
Were there any sworn allegations? Were there any sworn allegations of fact regarding the internal setup of that particularly described location?
Yes. So, Mr. Duval.
Where were those? Where were those, sir?
So at 835 to 36, Mr. Duval provided documentary proof as well as a sworn affirmation from counsel making clear there were 3 family units in the building. The motion papers themselves, the memorandum of law, also makes clear that the building was multi-dwelling. That's at A43, where counsel states the building is.
Counsel's affirmation doesn't constitute sworn allegations of fact, do they? What I was looking for is in the affidavit of the mother and things like that. I couldn't find any allegations specifically saying that they were separate units in that building. The closest thing, and it's alleged that the mother was the owner. She certainly would know, and anybody living there would know. All I saw was that she was living on the first floor and the defendant was living on the third floor. It almost struck me as being intentionally vague. So how do you take that sort of allegation and make it into a specific sworn allegation that would entitle you to a hearing?
So if I could just back up a little bit, this pleading defect that Your Honor is getting at has never been asserted until this point in the litigation. It's been waived. Mendoza is very clear on that point. It specifies a very important reason why the prosecution has to identify any sort of particular issue with the language in an omnibus pleading, and that's that the defendant needs an opportunity to be able to cure at that point. Sort of litigation occurs very early on in a criminal case. The defendant has very little information, especially in a case like this. It's really important that the prosecution be required, as Mendoza said, to make these arguments before the trial court. But going more,
Chief, if I may,
Judge Feiler?
Mendoza's talking about the situation where you don't have access to the information. I think the point of Judge Stein's question is you got the mom and the defendant and this other family in the middle between the two layers who are in the building. They have access to the information. They know what's going on. This is not a situation like Mendoza where you don't have access to the information.
Well, that would have been an appropriate argument for the prosecution to potentially raise before the omnibus court, but they did not. So that, again, the defense counsel could potentially cure any defect, but defense counsel was never put on notice. And this court has always taken a permissive approach. I'm sorry.
Chief, I had a quick question, if I might. As I read the appellate division, it's saying at a minimum that it believes that the motion court made a factual finding that this was a single family residence. And perhaps the appellate division itself is either affirming or making that same finding. If you assume that's true, how do we get past that?
Well, the appellate division majority made a number of factual and legal errors that are apparent from the record, make it clear that the conclusion to deny suppression was important. First
Is
of all,
is there no support in the record for the factual finding that this is a single family residence?
the record that's available to Mr. Duval, without question, the majority suggests, for example, that that the record showed that Mr. Duval's bedroom floor, but that was entirely misleading given the fact that the allegations in the affidavit very clearly state that Mr. Duval lived in the third floor apartment, the mother lived in the apartment, and then of course in the pleading you have the allegation, specific allegation regarding the tenants who are not related to the family in the second floor apartment. The other premise for the majority's conclusion was that there was a check found in a downstairs kitchen, but the record available to Mr. Duval only suggests that the check was recovered from after a search of the third floor apartment at 857. Majority
Judge,
makes
if I
this
may
confusing.
ask, follow up here. So,
Judge Rivera.
counsel, thank you. So, counsel, is your argument with this response to Judge Wilson's question that those submissions, at least on their face, suggested that as a matter of law, unless the prosecutor came forward with something else, as a matter of law, established that this was not a home where just either one family, him and his mom and whoever these other people on the second floor are somehow connected, or it's a multi-generational family, or several people are living there, but they don't live there in separate units. All areas of the house are sort of common other than the bedroom and available to everyone. Is that the position that you're taking, as opposed to, as Judge Wilson was arguing, which I think is a compelling point he's making, that isn't there really just a fact determination that's here, and that's not something that we can address?
Our primary argument as a matter of law, there were sufficient in the motion to controvert that were effectively uncontroverted by the prosecution because of their reliance on unincorporated materials, as they cannot permissibly do under Grow. But our secondary argument is that at least a hearing was required on the basis of the attorney affirmation, the HPD documents that were appended. The appellate division's
that's what I'm
reasoning
not understanding. What's going to happen at the hearing? What more is going to occur at the hearing?
The hearing, as many appellate division decisions bear out, which have looked at cases after hearing, as well as this court's decision in Rainey, I think also alludes to, would assess whether the officers knew or should have known whether the dwelling was multi-unit. So you would be able to take officer testimony and you'd be able to argue these details, these quibbles with the facts that my adversary attempts to draw out in their briefing. But really what they're trying to argue is that somehow the defendant needs to provide definitive or dispositive proof in order to get a hearing, but that's just not the standard under 71060.
Chief, I'm sorry, I have one more question now that counsel has mentioned Grow. So I perhaps understand Grow differently from you, but the way I read Grow, it applies to a situation where a warrant on its face lacks specificity. This warrant looks to me quite specific. It says an address, and here's the address of what's to be searched. If it lacked specificity, Grow then says you can't turn to unincorporated documents. But this warrant looks specific. You're not arguing that it isn't specific. You're arguing that it's wrong. And so I'm not sure why Grow applies to this circumstance.
We are arguing, despite my disagreement with Your Honor's narrower reading of Grow, that this warrant still fails under Grow because the phrase private residence is just impermissibly vague. All it indicates is that the premises are non-commercial, and really doesn't actually establish whether the magistrate intended the search of one apartment despite the broader scope, which is exactly the concern raised in Grow. There's no other limiting language, such as the name of the subject, the description of the area searched, as you saw in the prior case on the calendar, where there was a physical description of the home to be searched. This is a bare bones, in this case, it's a very bare bones description of the property at issue. And especially in a state like New York,
What
where
if it clearly was a single family residence? Would the warrant be sufficient if that were the facts?
no,
There's
it
no
would need to
question.
designate. It would need to designate at least. It would need to have some detail to at least establish that the magistrate approved of the search of the entirety of that single family dwelling. Some more detail like this is a house, as in Rainey, or as in the previous case on the calendar. There's no description of even that. A private residence really actually doesn't say anything about the place that's being searched. And I think a lot of this
What are
the
the magic words? So this is a house is okay, but a private residence is not okay?
A single family dwelling or a house or a description of the house as describing the overall property, the locations of the parcel itself, that you can see in most search warrants. Even
I'm sorry, Chief, once more.
Judge Wilson?
So 1022 East 211th Street, comma, a private residence clearly marked 1022 is in your view not specific enough to get a warrant.
That's correct, Your Honor.
Okay, thank you, counsel. Thank you, counsel. Counsel?
Yes, good afternoon, and may it please the court, Paul Anderson for the people. To address Judge Fahey's question of what was preserved, a motion counsel here was moving essentially for a Frank's Alfinito hearing, in which counsel was arguing that not only was this a multi-unit dwelling, the applying detective should have known this or made the application either in reckless disregard for the truth or made perjurious allegations. And so to get there, it's not simply enough to say that this is a multi-unit dwelling. You should also allege things that would put the officers or the detectives on notice that this is a multiple unit dwelling. And as Judge Stein pointed out, it does seem like counsel specifically wobbled on the edge to make sure that, to try to nearly insinuate that it's multiple unit, but never made the next step.
Judge, may I don't interrupt you for 1 second. One of the things that struck me in looking at this case is there was no search of the second floor living quarters, or if depending on what point of view you want to take, apartment. But that issue was unpreserved and no one really raised that, I don't think. Was that ever brought up?
Your Honor, it was not. There was no Garrison claim that, as counsel concedes, that's a separate Constitution issue. There was no claim that the officers were unreasonable in how they executed the warrant.
The way I understood they executed the warrant was that they whoever was living in the second floor apartment, they just saw the person and they didn't search that area and they went up to the third floor. And that jumps out at me to say, well, okay, if there's some proof in the record on that, or that issue was preserved, then you might be able to argue multiple dwelling. But I don't think there was.
Well, Your Honor, it's important to note that those allegations are from defendant. So he's nearly alleging this reasonable conduct that, oh no, my second floor neighbor his rights could have been violated, but he doesn't allege that they actually were. And so while he does suggest that it's multiple unit, it's once again under Frank's Alfinito, should the detective have known that, or was the detective disregarding
I see.
the nature?
Thank you.
Yes, Your Honor. And as to the argument of whether it's facially insufficient, a private resident, and by its plain meaning and by this court's own use of the term, signals that it's a single family, and especially when repeating the building number, again, saying a private residence clearly marked as, and then repeating the number, leaves no doubt to the executing officer that the magistrate authorized the search of this entire building, which the magistrate thought was a single family residence. And looking at the papers below the search warrant application, Grove really doesn't apply here, because there's a difference between arguing whether a warrant is defective or using papers to cure a defect. So here, of course, the court can look at underlying papers to see whether there's a defect in the warrant. And that's exactly what motion counsel below asked the court to do. Please look at these papers, see if there's probable cause for the whole building, and maybe we'll get a hearing on here.
So, Chief, I have a couple questions if I might.
Please.
Counsel, Mr. Duval, is it something of a disadvantage in being able to controvert the basis for the warrant because it's sealed and he couldn't get that material? Would you agree with that?
Yes, Your Honor.
Okay, so could he have made some sort of a showing to get a hearing that might have entitled him to some form of redacted or summary or some sort of information like that, in your view?
No, Your Honor, but again, the counsel did move to re-argue to try to get something similar, and the People v. Castillo motion to see whether that would be able to be unsealed. But once again, when the people responded with in page A73 of the record that the materials will demonstrate that the building is a one-family unit, defense counsel could have been like, okay, this wasn't a mistake where they left off the unit. They think that this is what happened. Defense counsel could have moved to or asked for an opportunity to file a reply, asked the mother to take pictures of the house, show the indicia, and then put in her affidavit, these pictures is how the house looked on the date the warrant was executed. It's a fair and accurate depiction. Create that issue of fact. Create that issue of fact that, oh, on the outside of the house, an officer should have known this, and therefore there must have been an allegation made in reckless disregard for the truth or under perjury, but that didn't happen here. And so while there is that slight disadvantage of they don't know exactly why the people thought it was why the officers thought it was a single family unit, there was still plenty of opportunity to demonstrate that anyone looking at this house should have known that it wasn't a single family unit. And if your honors have no further questions, I'll yield my time.
Thank you, counsel.
Thank you.
Counsel, your 2 minutes of rebuttal.
Briefly, Your Honor, I'd just like to go back to the question of whether this motion was adequately substantiated. It was more than adequately substantiated to at least warrant a hearing under the permissive approach that this court has always taken with respect to omnibus motions. The prosecutor below clearly understood that the argument was making was that this was a 3-unit dwelling and that he was attempting to controvert the motion on that basis. At A73, that's exactly what the prosecutor is arguing, that it was not, in fact, a 3-unit dwelling based on the unincorporated materials. And so the prosecutor didn't advance the pleading defect because that's the only plausible understanding of the moving papers. And just returning very quickly to Judge Stein's earlier question about what counsel can affirm or has to affirm, it doesn't have to be. Court has never required it to be exact. The statute specifically allows for a motion to be solely based on counsel's affirmation. 71060 sub 1 allows it to be based on information or personal knowledge. My adversary is basically proposing a standard that counsel at the very early stages of a case has to go out and get personal knowledge of all of these details in order to get a hearing on an omnibus motion. But that is a completely unworkable and impractical standard. As to the issue of the Franks Alfinito hearing, that's a standard that's applicable to probable cause. My adversary cites no case that requires the defendant to allege perjury on the part of an applying officer in order to make a particularity challenge, and it honestly makes no sense because cause challenge is only directed is directed to the incorporating papers, whereas a particularity challenge is solely addressing the warrant. So all that Mr. Duval needed to allege, as he did in this case at A44 and 45, is that the officer's own could have, he argued specifically that they easily ascertain the nature of the property and at 2 locations in his omnibus motion, and that was more than sufficient to get a hearing. Finally, as to the question to the execution, that argument was also more than adequately preserved by the moving papers. Basically, counsel, my colleague on the other side is conflating counsel's overbreadth analysis with his reasonableness analysis. But there's a distinct discussion in the moving papers of overbreadth separately from the information about the actual execution of the warrant. There's no plausible reason argument about the reasonableness of the execution presenting a range of the garrison. And again, under Mendoza, this court and the motion court was required to read the papers permissively so as to allow the defendant to obtain a hearing. Unless there are further questions. Thank you.